Good morning, this is your Kelso Report for Tuesday, January 8th, and I'm your host, Clark Kelso. We've got three cases today. In the first, the Ninth Circuit deals with the issue of accountability for a violation of the Eighth Amendment. Our second case involves possible government interference with a defense witness in a criminal trial, and the third case involves an anti-SLAPP motion involving reports of child abuse to Child Protective Services. We begin with the Eighth Amendment. Under the Eighth Amendment's deliberate indifference standard, an issue of accountability can arise when the government employee asserts that he or she is doing absolutely the best that can be done, given the resources provided by the government agency. Assuming that allegation is true, should the employee be held accountable, or should the government agency be held accountable? And does accountability change when the context is an action for damages as compared with an action for injunctive relief? Well, the Ninth Circuit addressed these questions in Peralta v. Dillard, which was brought as a Section 1983 claim for damages against an individual dentist who was employed by the California Department of Rehabilitation and Corrections. The complaint alleged that the dentist failed to provide constitutionally adequate dental care. The dentist moved for summary judgment, asserting, among other things, that he was providing all of the care he could provide given the resources available in the department. The district court granted summary judgment in the dentist's favor, and the issue before the Ninth Circuit was whether the district court properly took into account the limited resources available to the dentist. The Ninth Circuit held that in an action for damages against an individual employee where the evidence shows that the deficiencies in care were attributable to insufficient resources provided by the department and not to any misconduct by the individual employee, the employee should not be held accountable for those deficiencies. As a prime example, the court noted that CDCR policy at the time was to have one dentist for every 950 inmates. But that the resources provided meant the actual ratio was one dentist to every 4,500 inmates. Given this ratio, it was no surprise that the defendant was unable to see the plaintiff on a timely basis, and the defendant should not be held accountable in damages for that failure. Accountability in this instance lies much higher up within the Department of the Administration, so the Ninth Circuit affirmed the district court's decision. It is worth noting that the factual circumstances in this case arose in 2006 and 2007, before a federal court ordered system-wide improvements in the system of prison dental care, which included expanded staffing. And given those improvements, which the department has implemented, it is highly unlikely that this type of case would arise now in California's prison dental care system. Next, we have a case involving due process at a criminal trial. The fundamental guarantee of due process undergirds our criminal justice system. One of its many manifestations is the rule that the government may not substantially interfere with the testimony of defense witnesses by intimidating those witnesses into refusing to testify. You can cross-examine a witness, of course, but you can't threaten. In particular, while a court or prosecutor may remind a witness about the law prohibiting perjury, a court or prosecutor may not drive a defense witness from the stand by making unnecessarily strong admonitions against perjury that are aimed at discouraging the witness from testifying. In United States v. Juan, the Ninth Circuit extended this rule to a situation involving a prosecution witness in a case involving a prosecution for domestic violence. During a lengthy colloquy with the court, where the witness was not present, and this was the prosecution's own witness, the prosecutor suggested several times that he believed she was committing perjury by denying that the defendant struck her. Towards the end of the colloquy, the prosecutor suggested that she might actually need appointed counsel to advise her regarding the risks of perjured testimony. The judge agreed and appointed counsel without objection from the defendant. The next day, the witness changed her testimony and testified against the defendant. The Ninth Circuit rejected the defendant's due process challenge, noting that there was nothing in the record to indicate that the witness had even heard the prosecutor's threat of a perjury prosecution, or that her lawyer had communicated that threat. And absent that evidence, there was no evidence of causation and no basis for finding a due process violation. That she apparently decided to change her testimony after consulting with counsel does not violate due process. As a practical matter, it does seem to me that this is a pretty creative way for the prosecutor to get the message delivered without having to deliver it him or herself. Finally today, we have an anti-SLAPP case. Now, it's been a while since we've seen a published opinion under California's anti-SLAPP statute, which is designed to provide special procedural protections to communications involving free speech or petition involving matters of a public concern. In Dwight R. v. Christie B., the 4th District considered an anti-SLAPP motion in the context of a Section 1983 claim brought by a father against a marriage counselor and family therapist who had reported to Child Protective Services her belief that the father was sexually abusing his daughters. The daughters were taken away during an investigation which ultimately found no basis for believing there was any abuse. The lawsuit against the therapist quickly followed, and the theory of the Section 1983 claim was that the therapist had conspired with state officials by coaching the girls to make the allegations of abuse. The 4th District determined that the report of alleged abuse to Child Protective Services was a communication in furtherance of the rights of free speech or petition, specifically actions preparatory to or in anticipation of official proceedings, including an official investigation by Child Protective Services. Since the Section 1983 claim was based on those protected communications, the plaintiff was required to establish a probability of prevailing on the claim, which he was unable to do. The therapist's allegations were not borne out, but there was no evidence of a conspiracy. Not every mistake is a federal civil rights violation. In this case is a good example of the value of the anti-SLAPP procedure. We washed a bad case out of the system early in the process. And that's it for today's Kelso Report. Have a great day in the law.